So thank you all for joining us today for our presentation on the E-2 visa. We're going to be focusing on requirements for the E-2 investor visa, as well as things to keep in mind when you are eligible to renew your visa. My name is Dustin Saldarriaga. I am a senior associate at Scott Legal PC. With me on today's presentation is our firm's founder, Ian Scott. We're very fortunate to have Ian on the presentation because not only does he have extensive experience preparing E-2 visa applications, he has himself been on an E-2 visa for years and actually started our firm on an E-2 visa. So he's personally very familiar with the E-2 visa. A few things that are worth covering before we get started. Our firm, although we do focus on business immigration, our firm is a full service immigration firm, and we do handle family immigration cases, humanitarian immigration cases, as well as everything in between. So if you do have any questions about U.S. immigration law, please don't hesitate to reach out to us and schedule a consultation. We'd be happy to help. After this presentation, we will be sharing a few things with you all. We'll be sharing the PowerPoint presentation that you see on your screen. We'll also share a comprehensive guide to the E-2 visa, as well as a link where you can sign up for future webinars. We do try to do at least 2 webinars a month, and typically many more than that. And those cover a range of immigration topics. So we do hope to see you on future presentations. The email we'll send to you all will also have a link to our YouTube channel. And we really try to put high quality information for free on our YouTube channel. So please do take some time to check that out if you think it would be helpful to you. We do tend to post our full length webinars on our YouTube channel. So if there's something you want to go back and listen to again from today, or if you want to view our other webinars, go ahead and check out our YouTube channel. We will be monitoring questions, so if you do have a question during this presentation, go ahead and send it in using either the Q&A box on Zoom or the chat function. I have both open on my screen and am monitoring both. And if we don't answer your question in the moment it comes in, we will plan to answer it by the end of the presentation. We'll have time at the end, so do go ahead and send those in. All right, without further delay, I will go ahead and dive into the requirements for the E-2 visa, and later in the presentation, Ian will be talking about some other aspects of the visa, including some trends. And I will say I have had a bit of a scratchy throat, so please forgive me if I am drinking a lot of water and coughing every once in a while, but hopefully it won't be an issue. So let's start by going over the rules and regulations that apply to the E-2 treaty investor visa. And there is actually a lot there, even in the name of the visa. Treaty investor refers to the fact that this is a visa that's based on a treaty between the United States and another country. So there are dozens of these countries. We call them E-2 treaty countries. The first aspect of the E-2 visa is you do have to be a national of one of these E-2 treaty countries. The E-2 visa is a non-immigrant visa, which means that it does not lead to permanent resident status. It is intended to be short-term. Typically, it's granted for periods of between 3 months to 5 years. And can be renewed indefinitely. As long as you remain eligible and your business remains eligible, you can continue to renew it. But the non-immigrant aspect is that this is not a green card. It does not lead to a green card. So if you did want to apply for a green card, you could while you're on an E-2 visa, but that green card will have its own separate requirements. And the idea of the E-2 visa is that you are coming to the US temporarily to develop and direct a business that is based in the United States, of which you are at least 50% owner. We'll talk about that requirement a bit more on the next page. There are a few options to become essentially eligible on that ownership component. You can either purchase an existing business by at least 50% of an existing business, or you can start a business in the US. So that can be a startup that you're starting from scratch, or it can be starting a franchise. Those are kind of the three most common avenues that we see our clients follow, whether it's purchasing an existing business, starting a franchise, or starting a startup. All are fine for the E-2 visa. I already mentioned there must be a treaty between the US and the foreign country. And again, there are dozens of those countries. They are around the world: Africa, Asia, Latin America, Canada, Mexico, all over, Australia, New Zealand. So it is worth Googling. If you have a question about whether you're eligible, it's worth Googling E-2 treaty countries, and you'll actually see that list of countries. And I mentioned that the visa is valid for between 3 months and 5 years. That really does depend on your country of nationality. It's called reciprocity. And if you are at that lower end, we'll talk more about this, but you do have the option to extend your status from within the US. So it's not like every 3 months you need to go back to your home consulate and get a new visa. That's not the way it works. The visa is really just permission to request entry into the United States. And once you are in the United States, you are typically given you're given up to 2 years of status in E-2 status to run that business. And then at the end of that 2-year period, you can extend your status by applying within the US for an extension of status. Let's talk about get into a little bit more detail about the specific E-2 visa requirements. We've already touched on a number of these. You must be a national of a treaty country. That means you need a passport from a treaty country. It doesn't mean you need to have been born there. And in fact, you don't even necessarily have to have ever been to the treaty country. There are examples of people who were born in a country and received citizenship from another country through, say, a parent. And as long as they have a passport from that treaty country, they're eligible to apply for an E-2 visa. The other aspect of that is you can acquire E-2 nationality through investment. Grenada tends to be a popular country for this, where you invest in Grenada, and through that investment you receive a Grenada citizenship and a passport. You can become eligible through that. The big caveat there is that in the middle of 2022, the law changed that now requires that you actually live in that country for at least 3 years in order to qualify if you're applying based on citizenship that you got through investment. So the second requirement that you see on your screen is probably the source of most of the questions we get about the E-2 visa. So you must make an investment into the E-2 business, and that investment needs to be your personal funds. You actually need to show the government that you've put your own money on the line for this business. It shows the government that you're serious about it, and it also shows the government that the business actually has the money it needs and has spent that money on the things it needs to be operational. So the funds must be at risk. What that means is it's not sufficient to simply transfer your funds into a business bank account, because the idea is you can then simply transfer the funds out of your business bank account and back to yourself. You actually need to spend the funds. So you need to show that you've moved your funds into the business bank account and then spent them on an office space, on equipment, on inventory, on independent contractors, a website, marketing efforts, really everything that's needed for the business to become operational. You also need to show exactly where you got the money from that you're investing into the business. We call this the source of funds requirement. And fortunately, the government allows a wide variety of sources. So really, almost any legal source of funds is acceptable. The exception to that is if the source of funds is a loan that is secured by the E-2 company. So if you take a loan out, say you have a loan based on your home, a HELOC, that's fine. A loan that's secured by your personal assets is fine. A gift that's given to you by someone is fine, as long as you can document where that person got the funds. What is not fine is a loan that's secured by the business, but pretty much any other source of funds, as long as it's legal, is acceptable, and legal and able to be documented. So, if your source of funds is cryptocurrency where there's not a trail, it may be an issue, especially if you're applying through USCIS, but essentially Any legal source of funds is fine as long as it's not a loan secured by the business. Now, the investment must be substantial. We'll talk more about what that means on the next slide, because that is the specific question that we get most often, is how much do I need to invest? And the answer is it depends, but we'll give you more guidance on what it depends on the next slide. And as I mentioned, the funds need to have been spent. So you see on your screen typical E-2 expenditures. You see a list there, but really what this comes down to is at your visa interview, you want to be able to tell the officer that you've bought everything that the business needs for it to be operational once you get the visa. Okay, they want to know that once they give you that visa, you're going to be able to get your flight, come to the US, and everything's set for you to start generating revenue at the business. So show them that you've bought everything that the business needs. If you are purchasing a business, we mentioned before that buying at least 50% of a US company is a viable option for an E-2 visa. Typically a substantial investment amount is the fair market value for the business. So if you're buying half of it, it would be half of the fair market value. The third significant E-2 visa requirement that you see on your screen is that the business cannot be marginal. Marginal is a word that's used by the government. That means the business needs to be able to support more than just the E-2 treaty investor and their family. You actually need to hire US workers. We use as a general guideline, the business needs to employ at least 3 to 5 full-time equivalent US workers within 5 years of starting operations. So what that means is that you don't need to have employees before you apply. You don't need even to hire in your first year necessarily, but you do need to be able to show that you have at least a robust business plan that shows how within 5 years you will hire at least 3 to 5 full-time equivalent US workers. Now, you can certainly strengthen an application by showing that you have workers hired before you apply. In year one, that would make for a stronger application, but the requirement is not that you have employees before you apply. You need to employ workers or show the government that you will employ workers within 5 years of starting the business. The business must be real and operating. So I mentioned before that by the time you go to your visa interview, you want to show that all you need is that visa and the business will be operational once you arrive. You want to show that you've bought everything the business needs to become operational. You don't need to generate revenue before you apply, but if the business is not generating revenue, you do need a good business plan to show how you're going to get there and lead to those employment figures we talked about before. And in your business plan, in your application, the ways to show that the business is real and operating or ready to become operational, you can include, for example, a signed commercial lease showing you have committed space. You would show proof that you've created the company as an LLC, a corporation, any other legal entity for the business, that you have a website, that you've started marketing the business. You can also include evidence that there's interest in your products or services. So letters of interest from prospective clients. If the business is already operating, you can include contracts from clients. If you needed to, if there are certain weaknesses that you really want to strengthen the case, you can include letters from the local Chamber of Commerce talking about how your business will really benefit the area. Really, what we're doing here is showing the government that this is not just an aspirational idea, right? This is something that already exists, at least in its legal form, has already started marketing and has already started generating interest by the time you're applying. The fifth requirement you see on your screen is that you, as the E-2 investor, will be coming to the US solely to develop and direct the E-2 enterprise. So when you come into the US on an E-2 investor visa, you only have work authorization to work for the E-2 company. And your focus needs to be on developing and directing that company. So you need to show in your application that you're qualified to do that. You'll include your resume, you'll include copies of your degrees, whatever qualifies you to run the type of business you're starting. And if you're applying through USCIS, which is the option you have if you're already within the United States in another status, then USCIS does take a more critical look at this requirement. You really do need to show that you are managing and growing the business. You're acting as the entrepreneur and you're not acting as an employee. So let's say you're starting an accounting company. If you're applying through USCIS, you need to show that you're hiring someone, at least a part-time accountant, who is going to be providing the accounting services, and that you're not going to be the accountant providing those services, or at least not solely, because USCIS wants to know that you are not competing with domestic workers. Entrepreneurs do not compete. By definition, entrepreneurs do not compete with domestic workers. They create jobs. But if you are working as, for example, an accountant or providing direct services, the government can take the perspective that you are competing with domestic workers. And that is definitely a negative if you're applying. So you want to avoid that. Sixth requirement on the screen, you must own at least 50% of the E-2 company. That means that you can have a 50-50 owner, and your other owner can be also an E-2 investor, treaty investor. If they can be from another E-2 treaty country. They don't need to be from the same country. And really, as long as you own at least 50% of the company, your co-owner can be anyone. You can co-own the business with a US citizen, a lawful permanent resident, like I said, an E-2 treaty visa holder, or 1,000 other people. The requirement is really just that you own at least 50% of the company, and that is a threshold requirement, and it's also one you need to maintain. The moment your ownership percentage drops below 50%, you become ineligible for the visa or the status. So you want to be very careful that you maintain that. And finally, you need to have the intent to return to your home country upon expiration of your visa. So again, this is a non-immigrant visa. It's not a green card. So you do need to show the government you will leave at the end of your status. And that's usually easy to do. We include in our applications a signed statement from the applicant that basically says, I understand this requirement and I intend to leave at the end of my status. So I know a few questions have come in. The recording, there is going to be a recording. We will follow up by email with a link. We will also likely post this recording to our YouTube channel, so check that out. I am going to save the remaining questions. I think we're going to touch on a number of these as we continue. So we'll continue going, and then if these questions are not answered, we'll return to them at the end of the presentation. But do continue sending in any questions you have. How much investment is enough? What the government says is that you need to invest a substantial amount of funds into the E-2 business. There is no set dollar amount. This is in contrast to, say, an EB-5 green card, where the government specifically says how much you need to invest for an EB-5 green card. The E-2, there is no amount that the government defines. They just say substantial amount. And there are pros and cons to that. The con is that there's uncertainty. So, the government can deny your application based on this requirement if they just don't feel you've invested enough. Even if you've invested millions of dollars into the company, they still have that ability. On the other hand, and what actually we see more often is the benefit of this, which is if you can make a good argument, you can apply with a relatively low investment amount. And we actually have a separate webinar that specifically focuses on risky and low investment E-2 visa applications. So if that's relevant to you, check out that webinar. It's on our YouTube channel, several versions of it. And I'm sure we'll be giving another one soon. It's one of our most popular webinars. But point being, since many of the applications we handle, including Ian's own application for a law firm, which doesn't require a lot of money, you really can think about how to strengthen the application elsewhere and apply with an amount that's in the $100,000 or less range. However, let's get into a few more of these details. So what is a substantial investment amount really does depend on the type of business. A service-oriented business like a law firm, a consulting firm, does not require a lot of money. You need basically a desk, a computer. You need to have paid for the service to create the company, some marketing, and really that's it. So, you can spend $15,000 and say, I have everything I need for the business. The government is going to want to see that you've paid more than $15,000. 15 would be at the extremely low end of the spectrum and would definitely be a risky case, but we would look at ways to bolster that. Can you pay for more advertising? Can you pay for an office space, maybe 6 months or a year in advance? Maybe you need a new computer. There are ways to add to the amount that you spend on the business that do in the end actually support the business. We try not to recommend ways to just spend money for the sake of spending. We do try to look for alignment where it actually benefits the business. But if you do have a service business, the government tends to be more accepting of a lower investment amount, as opposed to, say, a manufacturing company that you need machinery, you need a larger space. There, the government will want to see that you've spent more on the business. And at the end of the day, what they're looking for is that you really have put enough money into the business to make it operational. As I mentioned, the overall strength of your case is relevant. So if you haven't spent a lot on your, say, law firm, and you really haven't taken additional steps to get letters of interest in your services, you haven't hired anyone, you really are trying to convince the government that you will do these things, that can be a weak and risky case. But if you have started hiring, if you have letters of interest in your business, there are ways to show that your application is actually stronger in spite of the low investment amount. And it's worth noting that where you apply also matters. So certain consulates are definitely stricter about the investment amount. USCIS tends to be less strict about the investment amount. So one of the services we provide is working with our clients to figure out where the ideal place to apply is. Just real quick, the government has published something called the proportionality test. What that basically means is the more money that's required to start the business, the lower the percentage of that amount the government expects to see in the application. So if you're starting a manufacturing company that requires $10 million to start, the government is not going to require that you put $10 million on the line. They might accept $8 million, for example. And that is, the proportionality test, frankly, is not so relevant for most of our clients, because most of our clients are investing with $100,000, $200,000, $300,000 that they've saved up to put into the business. And in those cases where the investment amount is lower, the government does tend to want to see 100% of the funds at risk. Just real quick, another way to bolster the amount, I mentioned Chamber of Commerce letters. You can also get a letter from a CPA that says that you've invested, the amount that's typical for that type of business. You can also include business articles from trade publications. Again, if you have a lower amount, that say you've invested everything that the business needs. Now, I mentioned before, if you're buying a business, the fair market value is what's relevant. So ideally, you'd be buying the business on the open market. You'd be able to show the business was advertised at a certain amount and that you paid that amount. If you're buying from a family member, someone who's close to you, a friend, be careful of that. You want to show that even though you're related to the person, you really did pay the fair amount for the business. If you don't, then the government can come back and say you didn't, invest a substantial amount into the business. Franchises do tend to be a great option for an E-2 visa. They tend to have a track record, so the government is more familiar with them. They also have that support of the franchisor, who tends to assist with marketing and assist with the software you need, things like that. So franchises can be a wonderful option for an E-2 visa. And common good and bad E-2 visa expenditures. Good expenditures are those really that are necessary for the business. You're spending money on things that the business needs to become operational. Bad expenditures are things that are not clearly needed for the business. So travel expenses. If you're coming to the US to look for a business opportunity, don't include that in the application. Typically don't include educational expenses unless it's a license that is very clearly needed for the business, specifically for the business, and not necessarily for your own education. We do spend a good amount of time working with clients on good versus bad expenditures. Do I have to hire employees? The answer is you do have to hire employees However, the question is when you have to hire those employees. You do not need to hire employees before you apply. Um, if you apply without employees, you would have a really good, robust, detailed business plan that is explaining how many of your products or services you're going to sell in years 1 through 5, and how that is going to generate revenue that you'll use to pay employees, and also it's going to create work that require you to have employees. So a business plan is critical if you don't already have employees. Even if you do have employees, a business plan can oftentimes help, and we'll talk about that more in the next screen. The Again, the requirement is that the business must generate sufficient revenue to support more than just the E-2 investor and their family. So if you do employ family members, they do not count toward the employment requirement. And in terms of who counts as an employee, who is a U.S. worker, frankly, it's really anyone who has work authorization in the U.S. But I would say that the strongest workers, there is a spectrum. So ideally, you want to have W-2 full-time employees who are U.S. citizens. Step down on the spectrum is if they're permanent residents, although permanent residents, it's excellent to employ them. So I wouldn't worry about that much. I would start to, at the weaker end of the spectrum are independent contractors, so those who are not W-2 employees, as well as workers who are themselves E-2 employees. So we in this presentation are talking about E-2 investors, but there is an E-2 visa for employees. So, if you're employing 5 E-2 employees, we would have concerns about that if those are the only employees you have. We would recommend, that you also hire domestic workers, right? People who are permanent residents, U.S. citizens in the U.S. If your business isn't in an industry that tends to focus on independent contractors, that can be okay, but that is something we would discuss with the client. All right, business plan considerations. A business plan, as I said, can be an excellent thing to include in an application, especially if you do not have employees at the time you apply. If you are who doesn't need a business plan? The applicant whose business, whether it's a business they started or a business they purchased, if that business has been operational for 5 years, 10 years, is already employing 3 to 5 workers regularly, then you can include in your application the company's tax returns, their W-2s that they've issued, and you can show that we are already satisfying the marginality requirement based on the business we're already doing and have been doing. And in that case, a business plan is less important. However, if you're applying and you either have very few employees or you don't have employees, or it's kind of cyclical where sometimes you have an employee, but at other times you don't, a business plan can be really critical, because what it does is it convinces the government official that you really do have a concrete plan to hit the hiring target, which is at least 3 to 5 full-time workers within 5 years of operations. A business plan should have an executive summary that really summarizes who the business is, who the applicant is, what they sell, who they sell to, and what their advantage is, and where they see themselves being in 5 years in terms of revenue and in terms of employment figures. It'll also talk about how they're going to market their services, how many people they're going to hire. We call this a personnel plan. So it specifically lays out in each of the next 5 years how many workers they'll have in what roles and what they'll pay each worker. And as part of the business plan, related to all of this and really key, is a comprehensive financial plan, which maps out the cash flow as well as the balance sheet, how the business is going to be doing in each of the next 5 years. So do you need to hire a professional to prepare a business plan? You do not. Some of our clients prefer to prepare their own business plans. However, I will say that this is not your typical business plan where you're, pitching to investors This is a business plan for the purpose of a visa. So I would say it is important to really focus the business plan on that intended audience, that you anticipate the questions the consular officer or USCIS will have, and you address those questions. And we do prepare business plans, and that is certainly the angle that we take on them. So I know that a few of the questions that came in were answered by that. And I think the rest of them, how do I show the amount of money that I've invested? We will touch, let's save that till the end. I'm going to go ahead and pass it off to Ian. I know he's going to touch on some of these aspects as well. And as I mentioned, Ian personally navigated this as he started this firm. So Ian, I'll go ahead and pass it off to you.
Great. Thank you very much, Dustin. So yeah, it seems like it was yesterday, but it was approximately 12 years ago when I went to the U.S. consulate in Toronto to apply for the E-2 visa for the first time. And since then have renewed it twice at the U.S. consulate in Toronto. And we are, I guess, E-2 success story is we have 10 full-time employees. And at the time when I started, it was low investment amount and just myself. So I think that's gives you a good indication of why the government and why officers like this program, and also what they're looking for. So in terms of a few things that can come up and often do come up when we're processing E-2 visa applications, and things that we try to make sure as we're putting together an E-2 visa application that the client is aware of these things and is focusing on these things. So Dustin spent a great amount of time talking about the investment amount, and that investment amount, you're really going to be spending money on everything that's required to get the business up and running. Now, the question then comes, well, where are you spending that money? And the relevant question for the purposes of this is, are you spending the money in the United States, or are you spending the money in some other country? Now, the regulations are crystal clear that there's no requirement to spend the money in the US. So let's say that a large part of your expenditure has to do with purchasing inventory, and let's say that you purchase the inventory in the UK, and then you ship that inventory to the US. That can all count in your investment amount. However, some consular officers, and in particular after the last administration where they had a buy American, hire American agenda, a lot of some consular officers will question and would certainly prefer the investment to actually be made in the United States. So what we try to tell our clients is that they should, having some expenditures that are made outside of the United States are fine, but we, as a ballpark, we say that try not to have more than 20% of those expenditures made outside of the US. So that's just something to consider, because a consular officer can raise it, and if they raise it, they may discount some of the expenditures that you have, and think that your investment amount isn't substantial. So something to consider. The second thing to talk about, and we see this more and more, and I don't know if it is a function of the fact that the government over the last few years has been accumulating a lot of, or collecting a lot of, social media data, but what we are finding is that sometimes they'll go for their interview and they'll be approved on the merits. So the consular officer will be happy with, the documents that they've presented, and that they're going to, that they've spent enough money and that they're going to hire US workers. But then they get put into something called administrative processing. And this could be a security issue. It could sometimes be as well that the consular officer wants a little bit more information. But this is something I'd say that I would describe it as a trend, because we see it much more now than we did, say, 5 years ago, or even 6 years ago. It's something that it's not, I wouldn't describe it as common, but when I went to renew my visa a year and a half ago, I have a very strong E-2 visa renewal, but my only concern was, well, what if I happen to get put in administrative processing, and then that process takes a long time to resolve? So in all of the cases that we have worked on, when people have been moved into administrative processing, and sometimes they have to fill out additional documentation related to security questions, because it can just be something as simple as a flag, like your name was flagged as because someone else has a similar name or something like that. but they, it's always been resolved. But there was one case where it took a year and a half to resolve it, and the person ultimately was granted the E-2 visa, but it took a year and a half to resolve. So that's something that something to keep in mind. Another trend that we're seeing is that before the pandemic, we maybe filed 5 to 10 USCIS applications, because the thing with USCIS applications is that they are not visas, right? So if someone's in the United States, they can file, let's say they're on an F status, and they can file paperwork to change to E-2 status, but that is just a status change, and it doesn't give them the ability to leave the United States and then re-enter. So the visa, for many countries, the visa can be issued for 5 years. So that's often something that people have a preference for in terms of getting, actually getting the visa. But because there are some consulates that are still delayed. So there was a massive delay in almost all consulates, if not all consulates, as a result of the pandemic. But now there's still delays. So to give you a good idea, Toronto used to process scheduled interviews within 3 weeks of filing before the pandemic, and now there's still 2 to 3 months. So it's gotten a lot better because it was over a year before. But sometimes people can't wait that long if they're purchasing a business, or if they are, they need to be in the United States faster, they are opting for USCIS. So we are seeing some USCIS filings, and then what they're concurrently doing is filing at a consulate as well, so that they have the USCIS approved, because you can pay for premium processing for that and have an answer in 2 weeks. And then, while they're waiting for their consular appointment, they are still able to run the business. So that's definitely something that we're, something that we're seeing. Because the problem as well is that the USCIS approval does not give you any benefit with the consulate. The consulate tends to ignore the USCIS approval. The the impact of this administration on E-2 visas, I would say there really hasn't been any. I'd say that while the last administration, there were a lot of areas where the immigration was maybe targeted. However, with E-2s, we didn't really see that much of a change. I mean, maybe one change is what I talked about earlier with respect to the investment, because they were the change in the Foreign Affairs Manual was that the entire manual should be read in with the preamble. They put something at the front of at the beginning of the Foreign Affairs Manual saying, buy American, hire American. So the rest of the Foreign Affairs Manual should be read in the spirit of this introduction. But that was a big change. But in terms of approvals, I don't think there was really much difference in the number of E-2 visas that were approved during the last administration and this administration. And that's very positive, because E-2 visa approval rates are quite high. So the government posted E-2 visa approval rates are over 80%, just over 80%. And that would include people who, some people who file on their own or have counsel that aren't familiar with E-2 visas, and includes also difficult consulates, because sometimes there are a lot of consulates out there that are quite poor. And that's just a government posted approval rate. So our approval rate is closer to the 98% mark, but past results don't predict future outcome. The in terms of COVID-19, this is, in terms of we might update this, because I think that now this is not as relevant. There's still delays. There's still some consulates that are delayed. Some countries are still not even processing E-2 visas. But in terms of requirement for a vaccine and testing, those things have pretty much gone away for entering the United States. I don't believe that certainly there's no testing requirement that is, and I don't believe that there's any vaccine requirement for non-immigrant visa people. I think there's still a vaccine requirement, a COVID vaccine requirement for people who are seeking a green card, right? So, some other areas for consideration when we look at a source of funds. So as Dustin mentioned, one of the requirements of an E-2 visa is that you have to show that the monies come from a legitimate source. Now, this is, for some consulates, this is quite straightforward. In particular, because so many consulates have a page limit. So if you're applying in Toronto, for example, there's a 70-page limit. So, and they don't tend to focus as much on where the money came from. in particular, if the money's coming from a Western country, if the money's coming from a country where the U.S. government believes that that country has a high amount of corruption, or the banking system isn't as robust, or the tax system, et cetera, then that there can be a bit more scrutiny in this area. But generally speaking, if we're submitting at a consulate, we might submit very little information with respect to where the money came from. Like if it came from savings, we might submit a tax return or two and then leave it at that. But when you are doing a USCIS filing, or if you're filing at some consulates that don't have a page limit like London, you do have to provide a lot more information. So, USCIS won't just accept like the money came from savings, from working, and then show 3 years of tax returns. They'll want to see the accumulation of the funds in a bank statement over time. So the documentation requirement is quite a bit more extensive than what you would need to show at a consulate. The money can be, the investment amount can come from a gift. That's not a problem at all. You just, if you do, as Dustin mentioned, if it does come from a gift, then you have to show where the person that's gifting got the money from. So the requirement would be the same as if it was your money. And it can come from a loan. And the only loan that you want to stay away from is a loan that is secured by company assets, because if it's secured by company assets, then that's not considered part of the investment amount. So it could impact your ability to meet the substantial investment requirement. Dustin mentioned we have a separate webinar on risky E-2 cases, and one of the things that makes an E-2 visa case risky is a small investment amount. So Dustin went over some strategies as well. We one mechanism to mitigate that particular risk is to spend more money. That's, of course, one mechanism. The other is to find other ways to strengthen your case. So maybe hire an employee or get letters of intent from people who want to hire you, or basically showing that your company can be or is viable. The other thing that you might want to do is, and we typically don't do this unless the case has been denied, but you may want to get a CPA letter that says that, the CPA has reviewed the business plan and the expenditures, and that the person has spent everything that's required for this particular business. The reason we don't like to do this CPA letter in the first instance, especially if the investment amount is low, is if the consulate might ignore it, and if they ignore it, then you don't really have, because if you're denied, you have to reapply, right? If they ignore it, you don't really have the ability then to give the consulate the exact same information that you gave them before. Where sometimes if you're denied with low investment amount and you spend a little bit more and then you get the CPA letter, that might be enough to convince them that you've met the requirement. An E-2 visa for investor, if you have two investors, they can, that's not a problem as long as they each own 50% of the business and they don't have to be from the same country. So if you had an E-2 investor from Canada and an E-2 investor from Japan, that would not be a problem at all. Now, when you go to the consulate and you say, so let's say that you have a restaurant and you apply for an E-2 visa, and then you go to the restaurant and you say, wow, the restaurant business is really tough and I'm not interested in it anymore. And instead I want to, provide IT consulting services because that's going to be a little easier than a restaurant. You can't just kind of change your business midstream unless you do something, right? You either have to apply to the government and for permission to do it. So change it if there is a substantive change in the business. Like what we try and do is kind of argue that whatever change that's occurring is not significant or substantive. But the example that I gave just now, it would be hard to argue that that change wasn't substantive because they're two completely different businesses. The other kind of area to consider is purchasing things from friends and family. So if you are purchasing a business from a friend or family, the government is going to scrutinize this. And the thing is even if the people don't have the same last name, just always keep in mind that consular officers, it's not their first rodeo, right? That's what they do for a living, is try and find out what's going on in a particular case, and they ask questions to be able to do that. So they could ask the question of, how did you find the business, right? And if they see you hesitating, or if they've done some research where they already know the answer, then it could be a problem. So then when you say, well, and they may even be more specific. Do you know how do you know the seller? And it's my brother-in-law or my sister or my mother or father. It's not that it's prohibited. However, the application is going to come under much more scrutiny, and you would want to, in that case, have a proper valuation and show the trail of the funds to show that the money's independent and that there really is an investment that is occurring. So we get this question a lot. Why are E-2 visas denied, right? So what's the reason they're denied? So there are a few reasons. So I'm going to jump around the screen a little bit. But so one of the primary reasons I think that E-2 visas are denied is that the individual has a business in their home country that isn't doing well or doesn't have employees, and then they want to start the exact same business in the United States. So that's a very difficult reason to overcome. So you might, if that's your case, you may want to hire employees in your own country before you apply. You may want to hire employees in the US before you apply, but it is a very difficult reason to overcome. Another reason we talked about is low investment amount, and we talked about the ways to overcome that already. Sometimes the nature of the business in our low investment amount and risky case webinar, we talk about this as well. Like sometimes business is based on real estate and or investment equity. They are considered passive. So as a result of that are much more difficult cases. Sometimes just where you file is a big issue. We had a staff meeting earlier today, and we were talking about filing an E-2 at a place that has a pretty bad reputation for filing E-2. So that's something to consider, because, although the rules are the same, all consulates are not, created equal. The other, the two big parts of an E-2, one is investment amount, and it's hiring employees. So if an officer doesn't think that you're going to be able to hire employees, or the business is one that's not going to be able to hire employees, they're not going to approve the E-2. Sometimes, we always encourage people to be quite deferential with respect to officers. They can say no, and they don't have to give a reason why, right? So that's sometimes it's better to be deferential than to try and make a point and then leave the consulate without a visa. And then the final reason is just that sometimes people are not eligible. I mean, this doesn't happen when we file applications, but sometimes people file an application and then they come to us and they're like, why didn't I get approved? And it can be as extreme as they're not from a treaty country. Because there's sometimes there are countries that were on the list and they're not on the list anymore. So they're on the overall list, but there's an asterisk, and the asterisk just was like, no future applications can apply. Or it could just be that they don't meet the requirement. Like that it's clear that what they didn't spend a substantial amount. Let's say they, bought a motel for $3 million, and $2.9 million of it was seller financing. And the government says, well, $100,000 you've invested is not a substantial amount. So those are kind of the key reasons why E-2s are denied. So the E-2 visas are issued for a period of time. So the time depends on which country you're from, primarily, because if you're from a country like the UK or Canada, the E-2 visa can be issued for up to 5 years. But then there's some other countries where it's less time. But when we're dealing with, for example, a country where the E-2 visa is issued for 5 years, then when you go to renew the visa, so when I went to the consulate to renew my visa twice, they're really looking at how many employees does the person have, right? So when we're really looking at about 3 employees, equivalent of 3 employees, so it can be 6 part-time employees or whatever, but the equivalent of 3 full-time employees within a 5-year period. And the salary doesn't matter. We do E-2s for pool cleaning companies in Florida where they pay minimum wage and under $8 an hour, however the minimum wage is there, and that's completely fine. They don't care about wage or title or level or anything like that, because there are some visas that do care about that, but not this one. We provide updated financial data with the renewal. I think though that with the renewal, the key thing really is employees, right? So, the tax returns for the last couple of years they're going to show a salary level, and we're going to include other W-2 and other information. But the tax returns are also going to show if it's profitable. And the government isn't looking for any particular profit. They're looking more at viability at that point. Like, is it a business that is going to be able to continue to operate? And sometimes when you have a renewal, the business is not doing well. It may not have employees, and we still can try to work with those cases. They might be more difficult to get renewed, but to show like maybe there's a specific thing like COVID happened and they weren't able to hire employees, but they have this plan in place to be able to do that. And then the other thing you have to look at with the renewal is just making sure that the person still meets the requirements, because all of the requirements that we talked about that Dustin went over, they still apply. So the company has to be at least 50% owned by nationals of the treaty country. The business has to be doing what you said it was doing at the beginning. So you do still have to look at eligibility to make sure that the person, because let's say the person sold 50% of the company, then or 60% of their company, and they were left with 40, then they wouldn't be eligible for an E-2 visa anymore unless that person that they sold to was a national of the treaty country as well. So
Great, thank you, Ian. So a number of questions have come in. I think we have about 9 minutes left. So a few of them I can go ahead and address, and I think there are a few that Ian, I think given your experience would be great for you
perfect.
to talk about. So let's just go down the list. Can I use a store or a restaurant business, even if I currently don't have experience in that area? It's a great question, and the answer is generally yes. You don't necessarily need to have experience in the specific area where your business will be operating. Something like starting a convenience store or a restaurant, you might point to your past experience that's somewhat related. Even, if it involves you working with other employees, maybe managing other employees, you can make the argument and advocate for yourself. Now, that being said, this is an area where a lawyer can help. So, I would say the takeaway is don't be the one to say no. I think it is certainly worth scheduling a consultation and seeing how you can really advocate for yourself and show how your experience does qualify you for the role that you want to have on the E-2 investor visa. I'm in the transportation segment. Our drivers prefer to be hired as 1099s, not W-2s. How can we do this? So 1099s are acceptable. They are simply weaker than W-2 employees. So if you are applying based on 1099 workers, a few things we'd recommend is have a higher number of 1099 independent contractors, where we would say to have at least 3 to 5 full-time equivalent W-2 employees. You may want to have 10, 15, 20 1099 independent contractors. It's also helpful to show that you work with the same independent contractors over time, that you provide them with a stable source of income. So how do you show this to the government? You would include the 1099 forms in your application, and you would show that as proof that you do actually provide work opportunities to 1099 workers, including the amount that they're paid. Would this visa make sense for a Canadian psychiatrist who wants to set up a private practice in Arizona or Florida? Yes, if you plan to hire U.S. workers. I would say that's really the only thing. The visa would not make sense if you want this to be just you doing that work. But if you plan to hire an administrative assistant, a marketer, an office assistant, people like that, and you can come up with 3 roles, then certainly this could make sense for you. Canadians are E-2 treaty country nationals. How do I show the amount of money that I've invested? That's a great question. What we do in our applications is we prepare what's called an investment schedule, which is an Excel spreadsheet that lists each and every expenditure that you spent money on for the business. It also would show kind of link to 2 things. First, a receipt or an invoice that we call proof of purchase, proof of what you bought. And second, the proof of payment, which would be a bank account statement or a credit card statement that proves that you actually spent the money on the item. So that is really how we would go about proving the amount of money you invested. The flip side of that is you would also show where you got that money from. So if you have that spreadsheet showing you paid $100,000, you also need to show exactly where you got that $100,000 from. Which states are better to get approval for E-2 visas? I have not personally seen pros and cons to any state. I think as long as you're within the United States, I wouldn't worry too much about where you're setting up shop, as long as your location makes sense for the type of business and its viability. For an E-2 visa application, does every joint owner need to have treaty nationality? No. As long as you have at least 50% ownership in the business and you are a treaty country nationality, it does not matter who else owns the rest of the business. But you do have to make sure to maintain that 50%. So I have a question about filing. Can I do it without a G28? I'm a foreign lawyer. G28 is just a document that says who your lawyer is. So if you don't have a lawyer, you don't need a G28. If you're applying based on yourself petitioning, you're preparing and filing your own application, you don't need a G28. A G28 is just to show who your lawyer is. Can you hire H-1B? You can hire H-1Bs. Generally speaking, they're probably not quite as persuasive as a U.S. citizen or a permanent resident, but frankly, as long as permanent residents and citizens are in the mix of the people you're providing job opportunities to, I wouldn't worry too much about it. H-1Bs would be fine, but of course, you have the separate requirement of actually applying on their behalf, which can be a long and drawn out process. How can someone get E-2 visa approval? I think the question is, how long does it take to get E-2 visa approval? Depends on the consulate. USCIS, if you are within the US, you can do a premium processing application and have a decision within 14 business days. If you're applying at a consulate, it really does vary. Some consulates are fast and will have you in for an interview within a month of applying. The vast majority of the consulates, though, it's closer to, I'd say, between 2 to 5 months from the date you submit the application and the date you're called in for the interview. And usually the visa is issued within 5 days or so of your visa interview. During the pandemic, a lot of companies got a PPP loan. That is one that I'm going to pass on to Ian in just a moment. Should all supporting documents attached be in English only? This depends on the consulate. So when you apply, you'll need to review the consulate's instructions. Some consulates will accept their local language. Other consulates do not. So you'll need to read the consulate's instructions. If you're applying through USCIS within the US, all documents need to be in English, or else they will not be considered. And there are rules for translations, which schedule a consultation if you have more questions about that, but typically not a family member. You need to have a certification included, things like that. We do have a blog post on that, actually. So if you Google Scott Legal PC translations, I think we do put that information on our blog. What if one partner is from Bangladesh and Canada, the other from India and not a treaty country? That could work as long as you own at least 50%. It doesn't matter who else owns the business with you. They might not be able to apply for an E-2 visa, but they'd have to satisfy the requirements on their own. For your application, you just need to own 50%. Timelines to complete an application as well as costs. Typically takes us 15 business days to prepare an application. We do have an expedited option that we offer. Fee, I would recommend reaching out to our firm and we can talk through whether you have dependents, whether you're applying through USCIS or a consulate, and we can give you specific information on the cost. If you schedule a consultation as well, that can be a great way to do that. All right, your business only needs to employ workers, so it doesn't matter what the business sells as long as it's legal and you can show that you'll employ workers. It doesn't really matter what the focus of the business is. If the employees are US citizens but do not live or present in the US, do they still count? Tricky question. I would be really careful of doing that. I mean, what the government's going to look at is, have you issued them a W-2 form? And there's a good chance the government wouldn't realize that they're not living in the U.S. But frankly, I would hesitate if you're employing workers that are not physically inside the U.S. I think it's a risk that you probably shouldn't run unless you really have to. Um, all right. How does the E1 differ from the E2? We have a lot of blog posts and videos on the E1, which is different from the E2. So do check out our YouTube channel and our blog posts on that. Reach out for a consultation. We do handle E1 visas, which are for treaty traders, people who sell to US clients. If I start a business in Florida, my daughter attends a university in South Carolina. Is she eligible for in-state tuition fees? That's going to depend on the state, and it's outside the scope of this presentation. Schedule a consultation if you have questions. Can I do the business at my own apartment? You can. There's no prohibition on that. However, it is going to make for a weaker application, and we do pretty much recommend for all of our clients that they actually have a dedicated office space and they pay a lease on that. It's an easy way to strengthen the application with not much additional cost. All right. Does buying a pharmacy qualify? As long as you satisfy the requirements and can show that you'll employ U.S. workers, buying a pharmacy can satisfy the requirements. Process, yes, you at a consulate you file the DS-160 first and follow it up with these supporting documentation if that's what the consulate requires. It does depend on the consulate, but the DS-160 is the first step for a consular application. Do I have to pay 100% of the business purchase upfront before getting a visa if I buy a franchise? You can use an escrow agreement. That is the one exception to actually putting your money on the line and at risk. But the escrow agreement needs to have as its sole condition issuance of the visa. If it has any other conditions, the government will not accept it. So Ian, there were a few questions here. Let's start quickly because I know we are a bit over time. The PPP loan, have you seen that being an
Yeah.
issue?
Yeah,
Yeah.
so not with the majority of people, but we have actually seen it as it has come up as an issue for some people, but it's just not common. So I think there's certain consulates that have focused on the PPP money and they didn't like it in the renewal, but I think it's very uncommon.
And then the remaining three questions are kind of all touching on the same thing, which is how does a pending green card application or a future green card application interact with being on an E2 visa?
Yeah, so I think that once you're on an E2 visa, if there's a green card category that is available to you, you can apply. So if you have a pending green card application, the one thing you always have to be conscious of is that the E2 visa is a non-immigrant visa. So if you have to renew the E2 visa during the time that your green card application is pending, then you may have difficulty renewing it. So I think that's something to keep in mind.
Perfect. So Ian, thank you. And to our participants,
Thank you.
thank you so much for the great questions. Very active audience, and that's awesome. Thank you for that. Do keep an eye out for our email with links to our YouTube channel and to the recording and the PowerPoint. We hope to see you on future webinars. Thank you so
Great.
much.
Excellent. Thank you very much, Dustin. And thanks everyone for joining. Okay. Bye-bye.